Welcome back, viewers, to the PI show. We've been talking about work cover litigation. However, now we've got Anna with our mailbag. Anna, how are you?
Very well, thank you, John.
How about work cover litigation?
Great show.
Supreme Court.
It's always interesting to see cases progress through, and every time there's an appeal you get new information and a different perspective.
I think that Sharif case, John, has brought us back a bit in terms of the rights of the worker. Because
quite clearly it's restricted rights in regards to a subcontractor, Tony.
Although, I guess it turned on its particular facts.
The particular facts, yeah. And in every case, there's particular facts that the judge always looks at. However, at the same time, I would have thought if you're a subcontractor, but you only work for a specific company, and that company provides you with a car and a uniform, for example, then I think you're in a pretty good position.
But it just highlights what I said before. They've got to take out insurance. Because people don't realise to take out insurance for yourself is probably a matter of a few $100s.
It's $500 Tony.
Yeah, it's very cheap.
Yes.
Okay, let's hit up some questions. Now, first one comes from Sarah in Footscray. Dear PI Show, last month I was paying for my dinner at a fast food restaurant when a light fitting fell from above. It hit the side of my head and my right shoulder. As a result, I now suffer from constant right shoulder pain, migraines and insomnia. I have not been able to work since the accident. I am a single working mother with young children and have been advised by my doctor that I will be out of work for at least another 2 months. My lack of earnings and my emotional stress has severely affected my ability to care for my children. Can I claim any compensation from the restaurant?
Well, Anna, it's clearly, Sarah, you need to see a lawyer. It's a public liability claim pursuant to the Wrongs Act, Tony. Clearly, I think for pain and suffering, you'd reach the threshold for the injury to your right shoulder. However, it has to be permanent, Tony.
More than 5%.
Yes.
You know, shoulder injuries are pretty notorious, so you'd need an assessment from a doctor to give you a more than 5% whole body impairment. That's for pain and suffering, loss of enjoyment of life. But she's also got a lot of...
Well, you've lost wages. There could be ongoing loss of wages.
There's got to be medical treatment, obviously.
Therefore, you need to see a lawyer to make a claim against the restaurant. I think negligence there's no issues there, Tony, is there?
Absolutely.
You're paying... I hope you didn't finish the transaction and kept the money, Sarah.
But John, significantly, the out-of-pocket expenses, which is loss of income and medical and associated treatment, you don't need the 5%.
Exactly.
So you can sue automatically.
Exactly.
And the thing is, the fact that the light fitting fell down, someone's going to be liable.
Oh, yes.
Yeah.
Again, we hope the restaurant has insurance.
You'd think they have.
You'd think so.
Yeah.
Hopefully
so
we've given
pretty good,
Sarah something to think about with those answers.
Get some advice.
Thank you.
Exactly.
On to our next question. Dear PI Show, 3 weeks ago I slipped on an apple in the fruit section of my local supermarket and broke my ankle. I have incurred medical expenses, but the supermarket is ignoring my request to provide an incident report or give me the CCTV footage. Do I have a claim? And that one's from Ning in Springvale.
This one here, again, the Wrongs Act applies, occupiers liability. I guess my only concern is an apple's pretty big. I don't know why he didn't see it unless he had a trolley in front of him and he's gone over.
A broken ankle would be quite a difficult injury, though.
It's a nasty injury.
But I'm talking about the issue of fault here.
Exactly.
And what's going to be important is you do need the advice, because the lawyers are going to have to go through the records to see how often they clean the shop, how often they maintain the shop, and then I guess from the injured person's point of view, why didn't he see the apple? It's not a grape or...
No, the pivotal question really is, Tony, did he keep a proper lookout?
And I don't know, I guess if you're pushing a trolley, you probably wouldn't see it.
How would Ning go about getting the incident report and the CCTV footage?
Oh, his lawyer will obtain that and request that pursuant to discovery, pursuant to the court proceeding.
Well, I think it's important that he sees a lawyer quickly to tell the supermarket to preserve the video, because more often than not, they'll just erase it.
Wow.
So it's critical that advice is sought very quickly.
And Tony, when you think about it, if he's fallen down and rolling in pain, it'd be ideal if someone got out their mobile phone and took a photo of the whole scenario.
And someone probably did. You never know. These days, it's amazing what they've got.
Everyone's got a mobile phone. Everyone's got video on the mobile phones. Videotape the incident. Videotape what's occurred.
Yep. But I think the two key issues in this case is, one, why did you hit the apple? Why did you fall over the apple? And two, the maintenance records of the supermarket. And that's going to go through the process of discovery and interrogation. So
You need to seek legal advice straight away.
well, there's no way an injured person would be able to do discovery, John.
No.
Lawyers don't know how to do it half the time.
Most lawyers don't either, Tony.
That's it.
Okay, on to the next question. This one's from Peter in St Albans. Hi, I was recently ejected from a well-known city nightclub and my arm was broken by the bouncers. The way they dragged me out was unbelievable. Is there anything I can do about this? Thanks, love your show, by the way. So that sounds like that'd be
Peter, it sounds like
tough.
you were stuck in King Street somewhere, Tony, in the middle of the night. Now, this has been occurring on and on, hasn't it, Tony? There are so many claims against nightclubs. In the end, they're supposed to provide patrons with a safe environment.
What would normally happen is you'd probably sue the person that broke your arm or the bouncers or security guards and the company that employs them if it's not the actual nightclub.
And the occupier also, Tony?
Yeah, usually if the occupier employs them, you sue them.
Yes.
If the occupier engages outsiders, you'd sue the company that employs them.
Yeah.
So...
and this has occurred quite frequently, for example, at Crown Casino too, hasn't it,
and because
Tony?
it's an assault, you don't need 5% for pain and suffering, John.
Exactly.
Really?
You just get... There's no threshold.
So ideally, he should actually make a complaint to the police.
Without fail. They'll investigate. They'll do most of the work for him.
Make a complaint to the police and seek legal advice immediately.
Well, John, I think it's important you get advice soon because there might be CCTV again, and that's one that they would want to erase.
Exactly.
Because it would implicate them criminally, apart from the civil side of it. So I think it's important.
Again, the issue of fault is at centre here, isn't it, Tony?
Yeah, and I think they will be at fault. The issue is whether you can bring it back to the company.
You think so?
Or the occupier.
Tony, what about if other patrons had done this injury?
That'd be more complicated. Look, we'll leave that as part of another show because
that's more complicated.
John's complicating things. Viewers, we love getting your questions, so please keep sending them in. You can also catch up on our old episodes on the website. Just to remind you, the website is www.thepishow.com. You can also contact us on our Facebook and Twitter pages.
John and Anna, thank you very much.
Thank you, Tony. Thank you,
viewers.
viewers.
Thanks for watching, and please stay safe. See you next time.